Hi, my name is Shannon Bales, author of the Trial Presentation Companion, a book on technology used at trial published by NITA, and managing director of FTI Technology's Forensic and Litigation Technology Group. I also teach trial technology at UCLA, and I'm on the California Lawyers Association Law Practice Management and Technology Executive Committee. I'm a specialist in trial technology, and I wanted to share with you 4 easy things you can do to dramatically lower your risk of a technical problem at trial. Lawyers have a duty to do technology right. You should be asking yourself, how would not knowing the relevant technology, or having an expert on hand, differ from not knowing the relevant law? I'm sure you would spend all night long learning a change in the law, no matter what it took, and tech should be no different. But many simply stumble through technology problems in court while judge and jury watch in frustration. Avoidable technical problems in court slow proceedings and taint judge and juror perception of the legal team. It is a terrible distraction to everyone in the courtroom when tech problems occur, and it can create a perception of incompetence. Most of the time, problems are avoidable by planning ahead, testing your equipment, and practice. The tech commitment from lawyers and legal teams is often so bad that some courts have created evidence presentation obligations. These are rules the court has created to mandate competent technology use in the courtroom. Some of these rules really illustrate how bad technology in the courtroom has become. These are from California and Kentucky, but I've seen frustration expressed nationwide by courts and jurors when lawyers do technology badly. The first rule, highlighted in yellow for those following the PowerPoint, is that the parties must familiarize themselves with their own equipment and how to connect their own equipment with the court system prior to the hearing or trial. Now, you should know how to use your own equipment. What the court is saying here is that they expect you or a member of your team to have tested and worked out any issues in advance with the courtroom equipment. Most courtrooms allow some level of access beforehand, or even classes to learn to use their equipment. You or your representative should attend. The next obligation, highlighted in green for those following along with the PowerPoint, the court strongly encourages parties to bring a backup laptop. A backup allows you to quickly recover when one computer crashes or breaks. Now last, highlighted in red for those following along, the court states that the parties will be required to present their cases without the aid of the electronic evidence presentation system due to equipment failure or due to any other technology delays. The court is saying they will not delay proceedings for you to fix your technical problems on your own equipment. So you need to get it right the first time, and knowing how to use your equipment and having a backup go a long way to accomplishing that. Cornell Law Review recently published a study titled, What Juries Really Think, Guidance for Trial Lawyers, written by Judge Amy St. Eve and Gretchen Scavo of Winston and Strawn. It is a study of 500 jurors from 2011 to 2017 in Chicago Federal Court and their attitudes on what they thought of the lawyers they saw at trial. In other words, what they liked and what they didn't. This slide shows what they liked the most. Now, number 1 was organization, preparation, and efficiency. And number 2 was delivery or style of presentation. Specifically, the study said, jurors like when attorneys use tech during trial to organize and present evidence. Basically, jurors want to do their service and get out. You can be the gas pedal or the brake on them learning about your case and making a decision or not. The study also stated that jurors like when attorneys use timelines and other efforts, for example, graphics and boards, to help organize and explain exhibits. According to the study, many jurors are accustomed to learning through technology, and technologically enhanced presentations present an ideal way to teach the jury. Jurors expect you to use technology effectively and efficiently. They don't want their time wasted and don't want a bunch of technical problems. Now, conversely, it was the same areas that the survey respondents suggested attorneys could do better in. They wanted better organization, preparation, and efficiency out of attorneys that they didn't think did that great of a job. They also wanted them to improve their presentation delivery or style. So improving in those areas will make jurors happier. Some of the comments from the study were, why couldn't the defense use laptops to present evidence like the prosecutors? And would have liked to see the attorneys operate computers better, or learn how to use equipment in advance, or like the attorneys put visuals on the screen. One of the first easy things you can do to lower risk is a site visit to the courtroom, specifically to understand the presentation environment. Test your laptop and its compatibility with existing courtroom equipment, and learn about any rules or tips for bringing equipment in. For example, you may need a special order to bring in equipment or to reserve equipment. There you should learn the court's likes and dislikes for technology use. For example, where do they prefer equipment to be placed, and to understand what the technical requirements are for your equipment to use the court's presentation system, or if you'll need to bring in monitors, projectors, or speakers due to court technical shortcomings. Many teams make assumptions about how easy it is to set up equipment and come into court day of trial only to fail. They either have problems connecting and configuring their own equipment or making it compatible with the court system. LA Federal Court IT once stated that the vast majority of technical problems come from people who never tested their equipment. They just walk into court day of and think everything will work perfect, and then when it doesn't, they are scrambling so they can present exhibits, presentations, and graphics that they may have spent weeks and months creating. It is important to understand your presentation environment. If you bought your laptop within the last 5 years, it is likely high resolution. Many firms create beautiful high-resolution presentations only to have them not be legible in the courtroom because courts often have equipment that is very low resolution. They do this to be backwards compatible with much older equipment or budget issues. We'll talk in a minute about some testing best practices. You may need to bring in your own presentation equipment like monitors, speakers, and projectors. If your eyes are rolling into the back of your head right now, you may want to consider a consultant that can help you with your technical presentation needs. The next thing to note in the courtroom is the shape of the monitors called aspect ratio and the resolution of the screens. Sorry for the tech terms, but this trips many lawyers up, making their presentations illegible. Resolution refers to the sharpness and clarity of the monitor you are using, while aspect ratio is the shape of the monitor. Basically, 16 by 9 is a rectangle, like a laptop screen or flat screen TV at home, and 4:3 is almost a square. Most laptops and screens built within the last 5 to 10 years are 16 by 9 rectangle, but there are still many courtrooms with older 4:3 screens. If you simply know which shape the monitors are and know the resolution used in the courtroom, you can fine-tune any presentation you choose to use in the courtroom. For example, with PowerPoint, once you know the shape of the screens you will present on in the courtroom, you can just go to the Design tab and select Slide Size and choose the right shape for your courtroom. This is custom tailoring for the courtroom you are in and often missed by lawyers. Next, you can find your resolution by right-clicking on your desktop and selecting Display Settings. This is showing a high-resolution setting of 1920 by 1080 on the second monitor. Display problems occur when there is a mismatch between the computer you created the presentation on and the one in court. Remember that court systems are built with backwards compatibility in mind, meaning really old computers that are not even close to the power of what most are using today. But the effect of putting your high-resolution and rectangle-shaped presentation on a low-resolution, square-shaped courtroom monitor can be disastrous. Side note, most new computers aren't even using a VGA connection anymore. They are all HDMI. Last, it's a good idea to cooperate with opposing counsel on the technical aspects of presentation. After all, you will likely be using shared equipment for presentation, so arguing over whose monitor to use is kind of silly. I find using a third-party neutral equipment rental vendor goes a long way to creating a stable and efficient technical environment. It also provides equal and fair access to technical support should a problem happen. Next, let's talk about testing your equipment. During your site visit, you'll want to test your equipment. Some courts mandate testing, and this is a good idea, while others may be reluctant to allow you to bring it in at all. You may need a special order to bring equipment in through security. These are things you'll want to ask while you're on your site visit. I like to use a test image that you can find online, but really any image will do as long as you can check to make sure you can see all 4 corners of the image to make sure the screens are configured right. It's also a good idea to create a generic slide with various font sizes and color on it to see what works in the courtroom. I can't tell you how many times you simply can't see the other side's presentation. When your laptop isn't configured correctly, your images and presentations might be stretched or shrunk, reducing visibility. This is very common and a tragedy because it is so easy to prevent. The bars on the side of the screen in a PowerPoint typically means the presentation was created in the wrong shape or aspect ratio, which I showed before. If you are the one doing the setup, I recommend the following basic steps, but you should make sure you are comfortable with your own setup routine before starting your opening statement. First, with the power off, connect your mouse, video cables, maybe PowerPoint clicker, everything. Then turn on the power and let your computer completely boot up and get logged in. Right-click and select Display Settings to make sure your laptop sees the other display monitors. Put up a test slide and make sure it can be seen on all the courtroom monitors. If using a video with sound, test the sound levels with a test video clip. Last, you may want to extend your display, but that is a more advanced topic. Last but not least, make sure you have the right power supplies and backup equipment, an additional laptop, and maybe a backup hard drive. I've been at several trials where the lawyer was sent with the wrong power supply and their battery died. Next, we'll want to talk about the exhibit number. I often think it's a good idea to give a tutorial on what the exhibit number is. It's an efficient means of communicating document information in court and to team members. You can quickly tell a lot about teams that don't use the exhibit number in court. First, you can tell that they don't have their data house in order, which is a tremendous weakness. Second, it opens teams up to a fair question that might break their rhythm. Counselor, for the record, what is the exhibit number? And teams often scramble, unable to find out what the right number is because they're using old production or Bates numbers from the document. So let's give a tutorial on what it is so we're all clear on which number is being referenced so there's no confusing with other numbers. Last but not least, the fourth tip is that you practice setting up and using technology in the courtroom so that you are comfortable with presenting electronic files. Get to know your PowerPoint clicker and how to refer to exhibits by exhibit number, and practice your technology presentation skills, and you'll do just fine. I'm Shannon Bales, and it has been a pleasure to speak to you today about the 4 easy things you can do to dramatically lower your risk of a technical problem at trial. If you want more info on technology used at trial, please check out my book, The Trial Presentation Companion, offered by NITA. Thank you.